Thank you for joining us for the second in our How We Live Safely podcast series. This podcast forms part of our How We Live campaign, where we are delving into important topics that are affecting the living sectors. In How We Live Safely, we'll be focusing on the implications of the Building Safety Act for those who are operating in that sector, although what we're discussing also has wider application than just the living sector. I'm Sue Ryan, and I'm a partner in the construction team and head of building safety here at Gowling WLG. I'm joined today by my colleagues, Gemma and Sean, who are part of the building safety team here. So, at the time of recording this podcast, today is the 6th of October 2022, we're now just over 3 months on from our first podcast, where we talked about the Building Safety Act gaining royal assent and the first of the provisions from the Act coming into force. At that time, we highlighted that there was still a significant amount of detail that remained to be finalised by way of secondary legislation coming over the next 12 to 18 months. So, my first question for you both is, what has changed over the summer? Have any significant strides been made in terms of the full building safety regime being brought into force?
So I think the simple answer to that, Sue, is that there have been some further developments in legislation over the summer, but not a huge number. So when we last spoke, we were on the eve of the key date of the 28th of June, which automatically brought into force some new statutory causes of action and extended limitation periods relating to civil liability for defective work, as well as those key provisions preventing leaseholders from being charged for the rectification of defects. So a couple of really significant parts of the Act there. We'd also just started to see secondary legislation being laid before Parliament. So the first set of commencement regulations, which brought in a variety of provisions, mainly including building liability orders. But we were waiting for further secondary legislation to bring into force and further detail a lot of the building safety regime. And since then, we have seen 4 further statutory instruments brought forward, which implement various aspects of the Act. So we've had a second set of commencement regulations, the Construction Products Amendment Regulations, Approved Inspector Amendment Regulations, and Leaseholder Protection Regulations. And while that might sound like a lot, there does seem to be quite an incremental approach being taken so far, with the bulk of that secondary legislation covering what we'd really think of as supplementary and consequential changes in the law, rather than the really significant changes that we're still awaiting. That said, there are a couple of very significant points coming out of the secondary legislation so far that it's well worth clients being aware of. So the first of these came out of the Commencement Regulations number 1, which we did briefly mention on our first podcast. These came into force on the 28th of May and set a timetable for the bringing into force of certain parts of the Building Safety Act. As I mentioned, most of those were either supplementary or fairly minor amendments, but probably the most significant provision brought into force was the ability for the High Court to now make building liability orders from the 28th of June 2022.
Oh, okay. So building liability orders are a new concept introduced by the Act. Sean, do you want to give us a brief explanation about building liability orders, please?
Yeah, sure, Sue. As Gemma said, the commencement number 1 regs brought in the ability of the High Court to bring in building liability orders, which are an entirely new type of order that's only derived from the Building Safety Act. What a building liability order does is to effectively make any liability that has arisen either under the Defective Premises Act or under Section 38 of the Building Act, or otherwise there being a building safety risk, that liability can be shared with one or more bodies corporate.
Now, in assessing whether a building liability order is made, the High Court will consider whether it is just and equitable for such an order to be made. Obviously, there have not been any of those orders made yet, so it's a case of watch this space to see what that test actually looks like in practice. Even still, there must also be an association between the original liability holder and the company that is the potential subject to the building liability order.
The test for association is fairly complex and set out in the Building Safety Act, but in very high level terms, it will effectively capture companies that were in the same corporate group or structure or have a commonality of directors between them.
Okay, so that's quite a significant power, and it'll no doubt have quite an impact on the way in which developers operate. What issues does that give rise to, and how will this give additional protection to tenants then?
So, I mean, I suppose initially from a client's point of view or from a developer's point of view, there's moving away from the sort of well-established principles of privity of contract and to a certain extent sort of looks to be piercing the corporate veil. I suppose the key takeaway in that respect is it militates against special purpose vehicle companies being used to hold or store liabilities, as those liabilities could ultimately be spread about amongst the corporate group, and particularly bearing in mind the extension of the limitation period retrospectively of 30 years under the Defective Premises Act, as we discussed on our first podcast. This could have quite a wide-ranging effect, as the order can be made with associated companies that have since been dissolved, which again opens up the net further in terms of association.
Well, it'll be interesting to see how that develops then. Gemma, you mentioned that there were other regulations that have come into force over the summer. Can you fill us in on those, please?
Yeah, so aside from commencement regulations number 1, there were also some substantive regulations introduced concerning approved inspectors and the construction product regulations, which were laid before Parliament at the end of June and came into force at the end of July. Although they provided really some relatively minor changes to the existing construction products and approved inspector regulations. There were also the leaseholder protection regulations that came in, which supplemented the existing leaseholder protections and introduced a new concept of landlord certificates, which I think, Sean, you wanted to talk about.
Yes, thank you, Gemma. So I think something that a lot of clients are going to need to be alive to is the regulations regarding the landlord certificate. It'll probably help if I explain what a landlord certificate is. It's effectively a list of information that can be requested at any time by a tenant as to the corporate structure of the landlord, or if the landlord is not the original developer, the corporate structure of the developer as well. Now, that information has got to be given in pretty short order, i.e. 4 weeks from the date of request, and it's got to be set out in a prescribed form, which is annexed to the regulations. Given the information required and the tight timeframes, it would be sensible for landlords to now be reviewing their potential obligations to provide such certificates and to have that information pulled together and stored centrally, so responses can be issued in good time. And I know sort of from experience, we've definitely had clients already contacting us in respect of this. So it's going to be an obligation that's going to be reoccurring quite regularly, I suspect.
Okay, thanks for that. And Gemma, I believe that there was one further statutory instrument which came into effect over the summer.
Yeah, the 5th statutory instrument that was made over the summer is, I think, particularly politically significant. This is the second set of commencement regulations, which again brought into force a few different provisions of the Act, but the most significant of this was sections 126 to 129. Which allowed Secretary of State to establish what the Act calls a building industry scheme for various specified purposes, but that includes securing the remediation of defects in buildings or a contribution towards the costs associated with such work. The provisions allow then for eligible persons to become a member of that scheme, but they also go on to say that where a person is eligible to join such a scheme but is not a member, the Secretary of State can actually prohibit that person from carrying out the development of land in England and can also prevent them from applying for or receiving building control approvals. So this came into force on the 1st of September and requires, again, further regulation to put into effect the detail of the scheme. But the government has indicated its intent to lay those further regulations as soon as practicable. And this all needs to be seen against the backdrop of the ongoing negotiations between the government and industry over the developer pledge, whereby I think at last count, 49 developers have committed to remediate what are called life critical fire safety works in buildings over 11 metres that they had had a role in developing or refurbishing. and then the translation of that pledge into contractually binding self-remediation contracts. And I think it's probably safe to say that the negotiations over those self-remediation contracts have been challenging over the summer, and clearly the bringing into force of this part of the Act is intended by the government as a signal of their intent to make good on their promise to bar access to the market to those industry players that it considers aren't acting responsibly. So I think that's a statutory instrument that's important to be aware of, particularly considering the background.
Yes, I think time will tell how that's going to play out, particularly now that we have a new Secretary of State in charge of the Department of Levelling Up, which is the third in 3 months. It sounds like, despite some considerable political upheaval since we last spoke, some progress is being made, even if it's very incremental. So what else do we now know about the secondary legislation that is still awaited, and has there been any progress on the commencement date of Section 38 of the Building Act?
Yes, in terms of the further secondary legislation that we're waiting for, there have been 3 consultations published by the government over the summer relating to the higher risk building regime, and I think this is probably one of the more significant developments to have taken place over the summer. The higher risk building regime, as a reminder, is the new, more stringent regime relating to the design, construction and occupation of multi-occupied residential buildings that are at least 18 metres or 7 stories. The first consultation earlier in the summer was in relation to refining the definition of higher risk buildings. And the second and third consultations were published together, and these related to the design and construction, and then separately the occupation phase of higher risk buildings. Those consultations, as you might expect, were quite lengthy and detailed, and we did publish some insights which we will link to alongside this podcast, which set out some of the detail within those consultations. There are a few areas that I think it is worth us just mentioning here, as they're areas that clients will need to start considering if they've got higher risk buildings planned for development or acquisition from 2023 onward. So the first of these is the implications of the gateway process and the approvals that will be required from the building safety regulator in relation to gateways 2 and 3, and also for changes made in between those gateways. So we spoke in the first podcast about the introduction of the new building control regime, and in particular about the approvals that will be required from the regulator at commencement and completion of the work, so gateways 2 and 3. And our latest insight was go into this in a bit more detail. Point to note about that is that the consultation suggested there could be a maximum 12-week period for the regulator to consider and approve applications at those stages. And if no approval is given at the end of the period and the applicant hasn't taken certain action by that point, then there would be a deemed refusal. Now, I know there is some concern in the industry about the length of that period, particularly on completion, and also around this principle of deemed refusal. So we will wait to see whether the consultation elicits any shift in position on those points. The Hackett review is also clear in calling for a stronger change control process, and the consultation set out the proposed requirements for implementing that also. So this includes the information that will need to be recorded in change control logs, as well as defining 2 types of control changes that will require engagement with the building safety regulator. So the consultation sets out a proposed list of what it's calling major changes, including things like changes to structural design, introduction of large panel systems, changes in fire strategy, evacuation routes or compartmentation. And these types of changes will require building control approval, which could take up to 6 weeks. And it's also proposed that there will be a list of notifiable changes, such as changes to the procedures for assessing competence, changes to the layout or dimensions of individual flats to the extent that that doesn't impact on the common parts, or the substitution of products that were referred to in the original building control approval application with like-for-like products. And for notifiable changes, it's proposed that they will need to be notified to the regulator and then can't be implemented for 10 working days, and then only if there's no intervention in the meantime by the regulator. So it's clear that clients are going to need to consider how change is managed in a more formal way, and also allow for any delays in the programme that may be caused by this process, and also to consider who is going to bear the risk of that. And the second area from the consultation that I do want to mention here is the plans for a transition period for the new building control regime, because that will be particularly of interest to anyone involved in higher risk buildings that might be scheduled to start over the next 12 to 18 months. So previously it had been suggested that all higher risk buildings would be transferred to the new regime whenever work on them had commenced. But the government have now accepted that industry concerns that this really wasn't going to be viable. They've said that they are concerned to make sure that developers aren't able, in their words, to game the system, but equally acknowledge the need for clarity and viability. So the plan is to have a transition regime in a similar way to that you'd expect for other building regulations changes. So there's a suggestion that there will be a 6-month transition period, and realistically we expect that to run between April and October 2023. So if an initial notice or deposit of full plans has taken place by the date on which the new regulations come into force, and work is then commenced within 6 months of the new regulations coming into force, then a higher risk building will stay within the existing regime. But if either of those criteria aren't met, then the building will be transferred to the new regime. And again, a couple of points on this. The first being that there is intended to be a new tighter definition of commencement, which means that if work has commenced on one building in a multi-building development, but not others, you could end up with some buildings being within the existing regime, but others transferring to the new one. And the second point to note is that this transitional arrangement would apply to design and construction only. Once the work's complete, if the building falls within the definition of a higher risk building for the occupation phase, and once the occupation phase of the Act is in force, the building will fall within that regime. And that includes requirements such as a requirement for a golden thread of information. So I think regardless of the statutory requirements during the design and construction phase, it is still worth considering starting a golden thread of information during design and construction, so that it will then be available for the occupation phase. So the closing date for the latest consultations is the 12th of October, and the government have said that they're aiming to publish their response within 12 weeks of them closing. So I think we can expect to see a bit of a flurry of activity probably early in the new year, with those regulations being brought into force, we expect in April, and then a transitional period running until October 2023. You also mentioned, Sue, section 38 of the Building Act, and this relates to some of those new causes of action that we mentioned in our first podcast. So as at today's date, this section of the Building Act is still not in force, although the changes that were made on the 28th of June did extend the limitation period for claims made under that section. So there seems to be a bit of confusion about how that situation has arisen, because the intention of the government clearly was that section 38 would be brought into force on the 28th of June alongside those other provisions. So we've written to the Secretary of State for Levelling Up to find out what's happening to bring that section into effect, but as yet haven't had a response on that.
Okay, well, thanks for that, Gemma. We'll watch this space then with regard to section 38, as presently really that failure of that section to come into force really undermines other provisions and the driving force of the Act. And it sounds like, although we don't know the final form of those new regulations, the consultations do give us some detailed information about what the government is intending to include. One final thing I think we have to mention if we're talking about updates relating to building safety from this summer is the case of Martlet Homes Limited versus Mulalley Co Limited, especially for those of us who deal with disputes. This is the first time the court has considered substantively a post-Grenfell external wall defects claim. And I wonder, Sean, if you could give us some of the key pointers coming out of that judgment.
Yes, Sue, thank you. Yes, it's probably one of the more keenly anticipated judgments of recent times, particularly for those of us, as Sue said, undertake dispute work. I suppose the real reason for that is until Martlet was handed down, there had not been any direct guidance by the court on how external wall defect claims would be assessed, particularly given the complexities of such claims with the sort of many and varied types of construction and the differing guidance associated with those types of construction. Perhaps conscious of the wider interest there would be in the judgment, the judge, His Honour Stephen Davis, provided a very, very full judgment, which runs to over 600 paragraphs, over 92 pages. So I'll do my best to summarise that. But I suppose that one of the key takeaways, and it was a warning given very early on in the judgment, was that the Martlet case itself turned very much on the specific contractual provisions and the specific fire safety standards applicable to those particular products, as well as the actual pleadings of the parties, how those pleadings were argued and the evidence called. So to take from that there's probably not any slam dunk conclusions to be taken, although I suspect there's probably some points of general application which I'll come on to. In terms of background, very briefly, the claimant, Martlet Homes, was the owner of 5 concrete tower blocks in Gosport, Hampshire, and the previous owner of the towers had engaged a design and build contractor, Mulalley, who are the defendant in this case, to complete a refurbishment work of the blocks, including the external wall insulation cladding to the buildings. As with most building owners following the Grenfell tragedy, Martlet undertook investigations into the adequacy of the external wall construction, which, amongst other things, included an expanded polystyrene or EPS cladded render system, which is not a product of limited combustibility and indeed can in occasion be quite combustible. So upon identifying this and also identifying various installation defects, Martlet put in place a waking watch and ultimately decided to replace the entire system at its own cost. It then turned to seek recovery of the cost of that remediation and other costs it incurred, including the waking watch from Mulalley. And on the basis that Mulalley had either breached its design or its workmanship obligations under the remedial contract. Ultimately, the court found that Mulalley was responsible, both for the workmanship defects, which were termed installation defects within the judgment, and design defects, which were termed specification breaches within the judgment, and awarded to Martlet the entire cost of the remedial works and the cost of the waking watch. So as I said, notwithstanding the early caveat and warning that this claim was very much decided on its own merits, that there probably are still 3 or 4 key points of general application that will provide welcome guidance to the industry, and particularly those involved with bringing or defending these types of claims. The first of those concerns comments made in respect to the building regulations, approved document B, or ADB as many people know it, and the BRE 135 report. In particular, the judge addressed the versions of the building regulations, ADB and BRE, that are in force at the time of design and construction of these properties. The particular versions that came under inspection, I suppose, in this judgment were building regulations as they were in 2002, ADB 2002, and then both the 1988 and the 2003 versions of BRE 135. I won't delve into too much detail because the judgment's worth careful consideration if you're considering any of those in particular documents, but just by way of example, the judge made a determination in respect of paragraph 13.7 of ADB, which was to the effect that when read as a whole, a designer could not assume that that provision did not place any restriction at all as to the use of combustible wall materials, and instead that it would be necessary for that designer to refer to the guidance in BRE 135. Then turning on to BR 135, the judge did make a further comment that the 1988 version was not a masterpiece of clarity, and the 2003 version could have been clearer. But yes, again, he did make comments which will be particularly relevant to those considering those forms of documents in the context of any claim they're bringing or facing. The second sort of point of general application is what has been termed the Lemming defence, as it were. And those who are used to or aware of negligence claims in particular would be familiar with the case of Bolam, which is often used as a defence to say that provided a reasonable body of experts would have taken the same approach, then the person undertaking that same approach would not be deemed negligent. The judge effectively, in this case, Mulalley, ran that defence to the effect of everybody else was using these materials and these constructions. So on the application of Bolam, that cannot be deemed negligent and accordingly a breach of contract. The judge rejected that approach and very much took the view that just because other parties were just as negligent, that doesn't operate as a get out of jail free card for any defendant designer. And I suppose that's quite a key decision, which I suspect will be heavily referred to by claiming parties going forward, as it is a fairly common defence brought by those defending these sorts of claims. And I suppose that the final real point of general application arising from Martlet considers sort of the linked concepts of causation and remoteness of damage. Causation within any claim is that you need to link the damage for which you are claiming to the alleged breach of contract or to the alleged negligent act, and that's often known as the but-for test. So, but for one thing happening, I would not have suffered this loss. Now, in this case, Mulalley took that approach by saying that the real cause of the building being renovated or replaced and the Wake and Watch being put in place was because of the Grenfell tragedy, and had that but for the Grenfell tragedy happening, Martlet would have not considered the external wall construction and certainly wouldn't have put in a Wake and Watch. The judge was not overly persuaded by that argument. As regards the but-for test, judge found that there was good cause for applying what's known as the effective cause test, as opposed to the but-for test in causation. And the thinking behind that was that the installation breaches were the effective cause of the loss suffered, which led to Martlet having to replace the cladding. I suppose it's probably quite interesting to hold that. The judge held that if Mulalley's only breaches have been the installation breaches and they're not the specification breaches, i.e. the design breaches, then Martlet would have only been entitled to the cost of the repair and not entitled to the cost of the whole replacement scheme. As regards to the defence for the remoteness of damage, this focused on the Wake and Watch costs incurred. And again, the judge was satisfied that those losses were close enough in proximity and foreseeable so as to be recoverable, not that they were too remote, which is the position adopted by Mulalley. The judge found that it was only the type or kind of loss and not the precise circumstances that needed to be foreseeable. And in this case, the need for temporary safety measures to mitigate a fire safety risk was sufficient to be foreseeable, as opposed to saying that we would specifically need a Wake and Watch in place over these buildings, for example. Moreover, the judge also found that the costs of putting a Wake and Watch in place were a reasonable step of mitigation on behalf of Martlet, as the only other viable alternative would have been to evacuate and decant the property and house the residents elsewhere, which I think all parties would have been agreed is a somewhat more of an expensive endeavour than putting a Wake and Watch in place. So I suppose those are probably the three key takeaways from that. And I'm aware that there was thought being given to raising or lodging an appeal to that, but I think, Sue, you understand that that's not now the case. So I think those are probably all I've got to say on Martlet.
Okay, thanks, Sean. So it's an interesting and informative case, and whilst there is always the underlying premise that each case has to be treated on its own facts, the cladding insulation material in question here, the EPS system that you referred to, is a proprietary system which was very commonly used. Certainly we've come across it in a number of the cases that we are involved in, haven't we? So it does provide very useful guidance. And also the points of principle coming out of the judgment, specifically relating to the lemming defence, causation and remoteness, are also very instructive. Well, that seems like a good point to end on. Thank you both for joining me this afternoon to discuss the recent updates to the Building Safety Act on our How We Live Safely podcast. Sign up to our mailing list to keep updated on the next episode in the series.